Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about the voluntary assumption of risk. Cases that should have gone to the Supreme Court of Canada, but didn't. Thomas Rivers went to a Little League game in North Vancouver. He sat in the bleachers in the back row to watch the game and to watch what was going on. Behind him was another baseball diamond, and Mr. Rivers got hit in the head with a foul ball from the baseball diamond behind him, not from the Little League game that he had come to attend. Mr. Rivers sued, arguing that a duty of care had been breached as a result of the fact that no protections were put in place to prevent him from being hit from another baseball game that he was not attending. And ultimately he was unsuccessful in this action on the basis of the fact that he had voluntarily assumed the risk by sitting in the bleachers that he would be hit in the head with a foul ball. And this case raises an important question about what is a voluntary assumption of risk. The question really was whether or not Mr. Rivers, in attending a Little League game, assumed a risk associated to a baseball game that was not one that he had gone to attend, and maybe he wasn't aware would be taking place or aware of the existence of the risk that existed at the nearby baseball field. The court had to look at all of the contextual circumstances to determine what a reasonable person would conclude. But unfortunately, we don't see a lot of jurisprudence coming out of the courts, and in particular appellate courts or the Supreme Court of Canada, really delving down into this question of what amounts to a voluntary assumption of risk. Obviously, if you go and play a sport, there's risks associated with that you're taking on. But a spectator to a sport is taking on a much lower degree of risk. And if we start expanding the assumption of risk to risks that are just around us, generally, of which we may or may not be particularly cognizant, aren't we watering down the duty of care that institutions and baseball diamonds and arenas and complexes where risks take place, where people go to participate in risky activities, owe to people who are not participating in those activities? This case, to me, seems to be a significant watering down of a civil tort standard that protects individuals against having to suffer from injuries for potentially the rest of their lives as a result of actions that they had no part or participation in. And that is not what the voluntary assumption of risk doctrine was ever created to present. So this is a situation where the Supreme Court of Canada should have gotten involved in this case and should have really clarified where we are, legally speaking, on voluntary assumption of risk and how much assumption of risk we have to make when we leave our homes to go through activities that are relatively otherwise normal in our daily lives. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada But Didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.